The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We have 3 cases for submission today. The first case is Sahinovic versus the State of Iowa. We will hear that orally. 2 other cases will be submitted non-orally, and they are Iowa Supreme Court Attorney Discipline Board versus Watkins and Iowa Supreme Court Attorney Disciplinary Board versus Kozlik. The latter 2 cases are deemed submitted, and we'll hear oral argument in Sahinovic. Mr. Smith.
May it please the court, opposing counsel. I want to run down to the facts of this case just very briefly, because while they're very technical, and I think that they're important. So Mr. Sahinovic was originally sentenced for robbery in the 2nd degree pursuant to a plea agreement back in 2011. And then the court decided Lyle. And because the court decided Lyle, it became the case that Mr. Sahinovic had an illegal sentence. Because he was a juvenile, he was automatically sentenced to a mandatory minimum. And so he filed a motion to correct legal sentence back in 2014. It wasn't until 2015 that he was ultimately resentenced. And after he was resentenced, he filed an appeal, a direct appeal from that resentencing, challenging various issues in that case. And then he filed a PCR shortly afterwards in 2015, which is, I guess, really where I think the argument is, because if that resentencing wasn't a final conviction, then his PCR was filed late. It was filed past the 3-year time limitation. And if it was a final conviction, then it was filed well within time. So the important part of the statute that I would ask the court to look at when determining whether this is a final conviction is 822.3, which says all other applications must be filed within 3 years from the date the conviction or decision is final, or in the event of an appeal from the date the writ of procedendo is issued.
Well, let me ask you this question. You cite Dauenbaugh, and Dauenbaugh, as I read it, stands for the proposition that conviction requires that there be a judgment. But in your case, there was a flaw in the sentence, the mandatory minimum. But part of the sentence, I think, was lawful. Namely, the ordinary sentence for robbery too. So therefore, the judgment wasn't really eviscerated by the Lyle ruling. Part of the sentence was, surely. So doesn't that distinguish Dauenbaugh? Dauenbaugh, I think the state will concede. We'll see when in a few minutes, I suspect. But the sentence, part of the sentence was illegal. But part of the sentence was not illegal, and therefore we do have a judgment. Anyway, respond to me.
Yeah, so Mr. Sahinovic's response would be that when you correct an illegal sentence and you have a resentencing hearing, that produces a new final judgment of sentence. That produces.
It's kind of right. I'm going to press you maybe with another hypothetical. Supposing someone is convicted of 4 crimes and a judgment is entered on 4 crimes. Appeal's taken. And one of the crimes on appeal, we decide, there's not sufficient evidence, and we vacate and remand. As to the one crime, of course, there is no final judgment anymore because we just vacated it. But the judgments with respect to the other crimes, I take it, are okay. The vacation of the 4th crime doesn't extend the time for PCR on crimes 1, 2, and 3, does it?
No, it doesn't. So it's still run from the date of procedendo. I think really you need that resentencing because that's what produces a new final judgment of sentence. And then that's exactly why he could appeal from that case, and that's exactly why he could file a PCR within those 3 years. And I guess I want to talk about conviction a little bit more from Dauenbaugh because I think that really that's why we asked for further reviews, because we thought the Court of Appeals was tripped up on it. And it's not...
Does it matter in this case that the original sentencing order was actually never vacated? As I read the second sentencing order, it amends the prior, which seems to me, although technical, that's an important distinction from a traditional resentencing hearing where we vacated the entire sentence.
I don't think that it matters much, because ultimately it was a resentencing. There was a whole entire resentencing hearing that was done, and ultimately
But in the absence of vacating the prior sentencing order, it still exists, right? I mean, it's still there. It still has legal effect. And with respect to this conviction, that sentencing order still has force, even though it's been amended to some extent, right?
I guess maybe I don't understand the question, or I disagree, because I think that by having the new sentencing hearing, that whether the
Well, here's what the sentencing order says. At the second sentencing order, it says, it makes an amendment, and it says, quote, all the other terms of the sentencing order shall remain in full effect. So the prior sentencing order was never vacated. It still has legal force and effect. So why should we start the limitations period from a different order?
I guess because there was a resentencing hearing done, and so like whether you call it an amendment or whether the court calls it a resentencing or whatever procedure had to happen after Lyle, that was done, and so maybe by implication it was vacated, and then produced a new final order of judgment, which he could then appeal from.
Let me ask you a question about the wording in Chapter 822. It does seem to me there's a lot of instances where the legislature uses the phrase conviction or sentence or conviction and sentence. And from that, I get the sense that running throughout Chapter 822, conviction means something other than sentence, so that you can challenge a sentence, you can overturn a sentence without affecting a conviction. What's your response there?
Yeah, from I can tell from 822.3 when they say that when the conviction or decision is final, I think they're referring to the final judgment of the conviction or sentence.
Well, why can't a sentence be a decision?
I think the decision in 822.3 is referring to like probation violations, which is I think in ground E, and so it's encompassing decisions that might not have final judgments, because there are many different grounds that you can have for a PCI.
The first sentence reads, a proceeding is commenced by filing an application with the clerk of the district court in which the conviction or sentence took place. Then we go down, we get to the sentence here which says conviction or decision is final. So you're saying conviction means two different things. One thing in the first sentence, limited to what we would call the adjudication of guilt, and another thing in the sentence at issue here, right?
No, I think I'm saying that conviction in 822.3 means one thing. It just means the technical definition of conviction, and I say that based off of how I read Dawnbaugh, and that the court had to decide what a conviction was for the purposes of 822, which ultimately said that the way that we use that read the post-conviction release statute is that we use the term conviction in its technical legal sense as opposed to the popular sense. So
well, I agree
adjudication.
with part of that, but I'm going to recast maybe what I began with earlier. In Dawnbaugh, it's a judgment. Conviction means judgment. Now, it happened to be a deferred judgment. And ultimately, the case was dismissed, and there was collateral consequences. As we know, the pharmacist ended up getting in trouble with the feds because he had a conviction under federal law. But the key issue in Dawnbaugh was you had to have a judgment for conviction. And frankly, I'm inclined to read that throughout, consistently. And it seems to me, although part of the sentence was invalid, you need to convince us that there was no valid judgment until a later date. So Downbow is not, although downbow involves a sentence in a sense, but it was the element that was required wasn't really based on sentence. It was based on a valid judgment. Correct me if you think I'm wrong, of course. But
from what I can tell from the court's prior rulings, judgment and sentence are typically used interchangeably, or they're used very, very frequently.
Well, you have to have a sentence. Let me put it to you this way: you're right on that 2/3, but ordinarily you have to have a sentence to have a judgment. But it seems to me here we do have a sentence, and the sentence is robbery 2, mandatory minimum, no, and that is corrected. But it seems to me at least the argument is that there is a valid judgment with respect to the ordinary sentence for robbery 2, the indeterminate sentence of however many years it was.
Right, and I would say that, when I read the court's opinions, judgment and sentence are typically used interchangeably. And even in the appeal statute, 814.6, they use final judgment of sentence.
Ask you this: supposing we have a invalid cost that's thrown into a sentence. There's let's just say a typo of some kind, maybe, or and costs of $5,000 are assessed or whatever. Illegal sentence as to the cost. There's no statutory authority, or it's way out of. So you file a motion for a legal sentence on the cost issue. Does that reopen all the other issues?
I don't think it reopens it, but if it produces a resentencing, then yes, I think that's a new judgment of sentence and produces both the judgment and the sentence. I guess. I
mean, Downbaugh was different in the sense that, as I recall the case, he got a deferred judgment and then met the conditions, and therefore kind of the judgment went away. Both as to the judgment as to the guilt or innocence, and the judgment as to the sentence. Whereas in this case, the guilt or innocence determination, it's still there, and at all times there was going to be a sentence imposed on that, and as Justice McDonald pointed out, maybe there always was a sentence in effect, right?
No, I don't think that I would read Downbaugh that way. I mean, in a deferred judgment, this guy pled guilty, entered a guilty plea, said he was guilty. The court then didn't impose a sentence off of that guilty plea, and then eventually it went away. So there never was a sentence. There never was a judgment. It was never a final conviction, and nothing he could ever appeal from to say that this didn't happen. Now, if he had somehow gotten that deferred judgment revoked, then he could have filed an appeal and said, well, actually, there wasn't a factual basis for my guilty plea, or whatever have you. Whatever.
Setting aside the issue of judgment, I mean, the relevant term is the conviction, right, in the statute.
I think so, Your Honor.
So I can think of 100 cases, probably panel decisions that I've sat on at the Court of Appeals, where we've separated and distinguished between a conviction and a sentence, where the order on remand is conviction affirmed, sentence vacated, and remanded. And that seems to me what's going on here, right? This conviction has never been vacated. The sentence was amended, but those are two entirely separate things, and we frequently distinguish between the two. Affirm convictions, send the case back for some sort of resentencing issue, but we never vacate the conviction.
Right, and I think that's why it was so hard and there was so much confusion, because there are two senses in which we use the term conviction, and the court has said in Downbaugh and in multiple other cases, and I can't remember it right now, but it was the case where someone received a deferred judgment and then wanted to possess firearms, that conviction changes based off what it means changes based off of how the statute uses it. And it depends on the context and how the statute does it. And so Downbaugh is talking about conviction in the technical legal sense, as opposed to that popular sense that the Court of Appeals might have been talking about in one of the decisions. And that's typically how I talk about it, and other attorneys talk about it too.
So our point is it might be more than two. Maybe there's more than one technical legal sense, and that's what we have to figure out here, right?
I think that the technically legal sense, the judgment and sentence are pretty closely intertwined in the sense that when you correct the sentence, you're entering in a new judgment. Other than that, I guess I want to get into the state's interpretation at least a little bit, which the state says that the question when you're looking at it is when the claim under 822.3 arose. For us, we say it's when is the conviction final, and that tracks the terms of the statute in 822.3. It uses the plain meaning of the statute to ask when you are going to file an application for post-conviction relief. And so for us, that's the superior interpretation because it relies on the language of the statute without looking further to what the legislature might have intended or could have intended or might have wrote. With that, I think my time is finished. Thank you.
Mr. Sloven.
Thank you, Your Honor. May it please the court. Counsel. Good morning. So I think the way our interpretation goes is that it's not just looking at when the claim arose. I mean, that's part of it. Looking at which instance of finality the claim refers to. And I think you're entirely right to note that there was a final judgment of conviction and sentence. Mr. Sahinovic was serving it. Then there was a correction to the sentence. And Justice McDonald, to answer your question, I think it is fair game to say if the sentencing order is amended to just strike part of it and otherwise left intact, there may not actually be a new judgment of sentence imposed there. The Iowa Court of Appeals exercised appellate jurisdiction through a notice of appeal, through an appeal as a matter of right. So I think that's a little complicated for us to assert here. But in many situations, you may have a correction to a sentencing order that doesn't impose a new sentence. If there's a Lyle resentencing hearing and then you impose some mandatory minimum, or you can see situations where you would need to impose a new judgment of sentence. But the question I'm getting to is this a claim that targets the conviction that was final, where there was a judgment of conviction and sentence, and then 3 years ran on that claim arose targeting that original conviction, the guilty plea proceedings, the original sentencing? Or does this target something about the resentencing? And to draw that distinction is the only way to effectuate the legislative intent behind any statute of limitations. I like to go back to Sparks v. Metalcraft to say, in that case, they're talking a little bit about the discovery rule, and they say the purpose of a statute of limitations is to give a fair amount of time for a plaintiff to bring the claim, but also to give the defendant a fair sunset period after which the claim is no longer available to be brought. And to restart the statute of limitations over and over defeats the whole purpose. I
think I am more inclined to approach this in a somewhat different fashion, and that is, Downbaugh's error. Maybe you overachieved in Downbaugh. I don't think so. But Downbaugh basically says we're not going to use conviction in the popular sense for purposes of the statute, that we are going to require that there be an underlying judgment. If the underlying judgment in this case was somehow challenged, it'd be a different matter. But indeed, as I was suggesting before, robbery to an aspect of the sentence was perfectly fine, was never really challenged, and therefore there was a judgment. End of story. Isn't that the truest approach to Downbaugh?
I think that makes the most sense. The most interesting thing to me about this Court of Appeals opinion is that it uses both of the definitions described in Doffenbaugh on the same page of the opinion. It refers to it as the technical legal sense, and then later it says it uses it in the general popular sense. But the interesting thing about Doffenbaugh in this context to me is that Doffenbaugh talks about 822.2 and 822.4, but doesn't really mention 822.3. And Justice Mansfield, you're correct that throughout the chapter, 822 uses conviction or sentence, conviction and sentence. But here we're talking about conviction or decision, which implies that for finality we're looking at something beyond changes to the sentence. We're looking at something different. Now, that's an interesting point that it uses both definitions. I actually think it doesn't really matter which definition from Doffenbaugh applies, because 822.3 says from the date the conviction or decision is final. And finality in criminal cases, when a conviction becomes final at judgment or sentence, and then also it attaches procedendo onto that, so you have additional finality there. Now, to say that the conviction becomes final is, you're referencing a finality interest very expressly there, and you're saying from that when it's final and enforceable, and all avenues of direct review are exhausted, that's where the statute of limitations really starts and runs. And once you start running on a statute of limitations like that, it subverts the purpose, the whole intent of it, to restart that limitations period over and over based on something that the putative plaintiff can control when it occurs, which is especially dangerous when you're talking about, I know that Lyle came out in 2014, but we've seen Lyle resentencings and sweet resentencings happening, even as recently as last year.
Okay, so is Downbaugh wrong?
I don't think so.
It was a position of state
I think
advocate.
Doffenbaugh could have come out either way. But I think that if Doffenbaugh was wrong, the legislature could have acted to correct that interpretation, and it hasn't acted to create a right of post-conviction relief in cases involving a deferred judgment.
I am disinclined currently. This is an impression, but I'm disinclined to say that conviction for 822.2 and 822.4 means something different than 822.3. And so I'm inclined to, context matters and all that, but I'm inclined to want to be consistent with our approach to definitions in the statute, particularly in such close proximity. Therefore, I am disinclined to depart from the Downbaugh treatment, unless you convince me that it's wrong.
I don't think that we need to either. That's the thing, is that our initial briefing, we worked from the assumption that it would mean the same thing, and on reflection, that assumption may or may not be valid because of different usage between the sections, but I don't think it matters because of the finality there. Now, if you use the Doffenbaugh definition, it kind of renders the word final there just a little bit of surplusage, because the Doffenbaugh definition, already a conviction is something that's final. It's a judgment and sentence. But again, I don't think it matters. I think what really matters is that 822.3 requires a conviction or decision be final, and then procedendo if there is an appeal, right? And that's when it starts. And if you're targeting the conviction that was final, now this is the second half of it, is what does a motion to correct an illegal sentence really do? Does it undermine the finality of the conviction now this is the general popular sense of the word conviction, I'm using it now. Does the motion to correct an illegal sentence undermine the finality of that conviction? No, we know that it can't. We know that it can't challenge the underlying conviction, the determination of guilt or innocence. It can't undermine the finality of that. It can change the sentence, and it can result in the imposition of a new sentencing order from which you can have a right of appeal, and that's the discussion of props. But can it deprive the original conviction of the finality it had? No. Can it change the fact that the statute of limitations, starting from when that conviction became final, has already run? No. Now, if somebody receives ineffective assistance of counsel at their resentencing hearing, where a motion to correct a legal sentence is granted, you need to have a hearing because you're going to impose, you need to have a sentencing hearing for some reason.
I'll give you a hypothetical. Let's say you have somebody who is found guilty of 2 offenses, and they're sentenced, they receive a sentence for each offense, and then later on there's a motion to correct the illegal sentence complaining about one of those 2 sentences. Mm-hmm. Does that, in your view, open up the 3-year period to challenge the other sentence if one of the sentences is set aside pursuant to that motion?
I don't think it would. I think I understand, and I don't think that it would open up that 3-year period. And like I said, and I think that the real question has to be: has the statute of limitations already run for the challenge that is being raised, for the PCR claim that's being raised? If the PCR claim attacks something about the conviction or that was final before the motion to correct an illegal sentence, if there was already finality inherent in that, and then 3 years ran, well, you're outside of the statute of limitations on it. And filing a motion to correct an illegal sentence that changes something different about the sentence, I don't think that changes the finality inherent in the conviction. Now, if you want to, on the one conviction that you're describing, Justice Mansfield, where a new sentencing order was entered, if you have a PCR claim that targets the part of that specific order, something that happened in producing that, where that statute of limitations would start to run when that sentence becomes final. And I don't think that, now you can say that the sentence wouldn't exist but for the conviction, but for the ascertaining of guilt and innocence previously, but we already had a statute of limitations on that conviction or decision when it became final. We already had that. That already ran. And it would subvert the purpose of a statute of limitations to restart it based on, there's not even a discovery of new facts.
I agree. We all think the legislature didn't intend the result that Mr. Smith's advocating for. But the question is what the statute requires. You can raise a motion for an illegal sentence at any time. So if a motion for an illegal sentence could open up a conviction, then a guilty plea or a guilt adjudication, that's not intended. But the question is how we get there. Is it your view then that even though the statute says conviction or decision, the conviction or decision is if there's just one conviction, you actually go piecemeal and you parse it into different components and say, is the component of the conviction being challenged final or not? Is that your position?
I think so, and I think that it's not about parsing for because each individual claim is a singular PCR claim. Parts of an action can be time barred, whereas other parts of the action are not. 822.3 already envisions that, where it says, some of your claims may be based on new grounds of law, some of your claims may be based on new grounds of fact. It envisions going claim by claim through to see if it's time barred. And I think that same approach is possible here when you're talking about if you're targeting, one of your claims targets the conviction, the ascertainment of guilt or innocence, and that has been final and was final for 3 years before an illegality in the sentence was corrected.
It seems hard to square with the statute when it says the conviction or decision became final. To then say, well, for any given PCR, there could be multiple different dates depending upon what's actually being challenged, right?
Well, it's possible to bring a PCR claim that involves multiple different convictions, multiple different decisions, and you would necessarily have to go. If they're in different case numbers, you're going to have to go case by case there to figure out the date of finality for each of those convictions or decisions. And I think that, and especially, you're going to have to do it anyway if you're talking about when new grounds of law emerged, when new facts were discovered. I don't think it's inconsistent with, I think the only way to do what the statute is trying to do to provide a fair window to bring each claim, because we know that the statute of limitations can't have run before the claim could have been raised. That would be unfair as well. And if there is a claim that's targeting, right, I think that there has to be a reading of the statute that squares the fact that a motion to correct an illegal sentence can produce a new sentencing order that has new problems that weren't there previously and should be able to be challenged through PCR. That can happen. But what it can't do is undermine the finality of the original conviction. It can't change the fact that there was already a date of finality, and there was already 3 years that ran since then. And claims that could have been brought then, they already arose. They were there throughout the running of that previous limitations.
Let me give you another hypothetical. All right, you have conviction and sentence become final in 2011, say. In 2013, there is a motion to correct an illegal sentence, which is granted, and there's a resentencing in 2014. Then in 2016, there's a PCR. So what do you do there? Because in that case, your conception that the 3 years ran from has already run from a final conviction and sentence. That never occurred.
Well, as you describe, so wasn't the conviction final before the filing of the motion to correct an illegal sentence in that instance?
It was final, but the 3-year statute didn't
but
run.
before 3 years had run. Well, but then you would still have the underlying conviction that was final and was unaffected by the granting of the motion to correct an illegal sentence, that you still had the finality of that would have run at some point after the correction of the illegal sentence. And then you would still be within 3 years of the corrected sentencing order, but you already would have exhausted your direct appeal from the conviction itself. And again, I think that I see my time's expired. Thank you. And I see that it can become necessary to parse out whether a claim targets the ascertainment of guilt or the trial or the resentencing. I think that's necessary anyway to go claim by claim under 822.3. And I think the only way to accomplish the aim of the statute is to say there's 3 years from when the final judgment of conviction is entered. If a motion to correct an illegal sentence can't affect the finality of the underlying conviction itself, then it shouldn't be able to restart the clock on other attacks that would attempt to undermine the finality of the conviction, nor should it restart the clock that runs from the finality of the conviction. Thank you.
Mr. Sloven. Rebuttal.
So the state's interpretation of the statute, where we're parsing out different areas where we're going to then attack, it's not supported by the language in the statute, and it honestly sounds unworkable for any sort of PCR. I disagree. I think the legislature intended the result that I'm talking about. It's actually a very easy rule to apply.
How far does that rule extend? Is it your position that any amendment or correction to a sentence restarts the statute of limitations?
I would say that any resentencing, and that works then for any time that someone needs to be resentenced. If you send an appeal back because there was an error in the sentencing process, the question that the district court judge or the Iowa Court of Appeal judge needs to ask is, okay, when was the date of resentencing? Was this person resentenced? Okay, then they can file an application for post-conviction relief.
When you say resentencing, you mean the actual holding of a resentencing hearing?
I would just say if you change one of the terms of punishment.
That's
right?
an amendment.
That's an amendment.
Right?
Well, I guess...
Let me give you an example. This morning I came across a case that vacated the $10 domestic violence fee as an illegal sentence because it wasn't authorized by statute in that particular case. So let's assume we have a case and the defendant files a motion to correct an illegal sentence 5 years after the date of judgment entry, and it's to vacate the $10 domestic violence fee. If the district court grants that order, amends the sentence, strikes the domestic violence fee, in your view, does that reboot the statute of limitations?
Yes, that's a resentencing, and after that, it's a bright line rule. And
you're aware of all of the Albright stuff that's been going on.
Those are restitution issues. Generally.
But the example he gave is a very common, popular problem where unfortunately maybe a district judge gets really busy on a motion day and maybe approves orders that are before him, and those assessments are very easy to get incorrect. That was a great example of one. You're saying something like a $10 domestic violence fee 5 years earlier can open up Pandora's box for post-conviction relief?
If it results in a new resentencing, it produces a new final judgment and sentence. It's a new term of punishment. When you file a motion to correct a legal sentence, it produces that new judgment of sentence. That's why you can appeal from them. And that's another thing. And 822.3, final usually means last. And it usually means you can appeal from it. When we file this motion to correct legal sentence...
What's unworkable about the state's position that if you're targeting if the PCR claim targets the conviction, you got 3 years to bring it. If you're targeting an error in a resentencing some years later, you got 3 years from that resentencing. I don't see why, I don't see why a resentencing error that has no effect on the underlying conviction should open up that conviction for challenge years, maybe even decades later.
Because then the question becomes, well, what about the decision? I mean, you got to file your PCR for your counsel that was ineffective on your motion to suppress within 3 years of that, and then you got to file your PCR for your counsel that was ineffective at your trial within 3 years of that, and then your counsel that was ineffective at sentencing within 3 years of that.
Because the ruling on the motion to suppress is interlocutory until there's a trial or a plea or a conviction, and then that's when you have finalities. Don't we look for finality? Could you take a direct appeal from it?
Yeah, and that's exactly what I'm saying, is that because this produced a new sentence that could be appealed from, it was final. And he did take an appeal from it, and it was ruled on. If he had filed the motion to correct a legal sentence and it wasn't ruled on, if it was denied, they said, no, you don't get it, then he wouldn't have a new judgment of sentence. He wouldn't have been able to take an appeal from it. He would have had to file a petition for it to cert and said, well, the court took an illegal action. But because it produced that new sentencing that he could appeal from, a new final judgment of sentence, that was the thing that mattered. So you just ask, is there a resentencing? The court can always say, I guess, I don't think the court needs to necessarily require that those fines and surcharges, that those all need to do that. Because in this case, it was mandatory minimum. It was a pretty big deal. So the court can, I guess, differ in some ways. But in this one, yes, I do think that it would produce a new final judgment of sentence to remove that mandatory minimum. I see that my time's almost up, so if there aren't any questions, I'll say thank you and goodbye.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.